All right, good afternoon, everybody. Today is March 26th, 2026. The time is now 2:01, and we're going to begin. My name is Jonathan Vela from the Department of Consumer Worker Protection, part of the External Affairs teams. I just want to give a big shout out to Clea, who is our social media manager, helping us out today with the live streaming. And we have a big agenda today. But first in our agenda, we have a special speaker today. You might know him as a former director of the Federal Trade Commission and our serving commissioner as of January 2026. Please welcome Commissioner Samuel Levine.
Well, thank you so much, Jonathan, and thank you to everyone joining us today, both from DCWP, Small Business Services, and especially all the small businesses that are joining the call today. We're here to talk about protected time off and the really critical rights that New York City workers are entitled to under the law, and those rights have been evolving and expanding. But what I really wanted to say is we are here to stand up for workers and make sure they're entitled to their rights. But we also really want to make sure businesses understand the law. We are not here to play gotcha. We want an environment where all businesses understand their obligations, where all workers understand their rights. We want to make these laws as simple as possible, as clear as possible. And frankly, the fact that so many of you are here, I think you're doing exactly the right thing, trying to make sure you're respecting your employees' rights and complying with the law. And we, along with our friends and colleagues at SBS, are here to help. So we really just wanted to thank everyone who is making this event happen. If there's more we can do after this event to support your business, to support other businesses, and making sure they understand their obligations around protected time off, we are here for you, and I know SBS is as well. But first and foremost, I really just wanted to thank you for being here and wish you a really constructive, educational, and engaging event today. Thanks very much, Jonathan.
No, thank you so much for taking such time from your busy schedule, Commissioner. Yeah, we definitely have a big agenda today, you know. And if everybody wants to be up to date with everything that's going on here at Department of Consumer Worker Protection, please follow us on our social media at Hello DCWP. I do want to give a quick reminder. I know there's going to be a lot of information today, but you can always visit nyc.gov/workers, and you can always ask your questions there. And just make sure, you know, anybody, whether it be a worker, an employee, a representative of a worker, or a representative of an employee, you're able to ask these questions. Well, to get started, I would like to introduce our main event. We have from the Office of Labor and Policy and Standards, staff analyst Alex Reese.
Thanks, Jonathan. Good afternoon, everyone. I am going to share my screen and hopefully we're all set. Okay. So as Commissioner Levine mentioned, I'm going to be giving you an overview of New York City's Protected Time Off Law, or PTO. I'll give you a brief overview of what the law entails and then some examples. And along the way, I'll answer a few questions that we received prior to today's presentation. Be sure to keep an eye on the chat as well, because there are a few links throughout that Jonathan will be sharing throughout the presentation that are helpful tools. Again, all of it's available on our website. So if you don't see it in the chat, you can definitely still access it. So the New York City Department of Consumer and Worker Protection, or DCWP, protects and enhances the daily economic lives of New Yorkers to create thriving communities. DCWP leverages its authority to bring New Yorkers real economic relief and protect them from predatory, deceptive, and unfair practices that violate their rights as consumers and workers. This includes pioneering cutting-edge protections such as the city's Consumer Protection Law, Protected Time Off Law, the Fair Workweek Law, and delivery worker laws. Through licensing more than 45,000 businesses in over 45 industries, DCWP ensures fair competition and a level playing field for responsible small businesses, that are integral to New York City's vibrant communities. As a staff attorney on the worker protection side of the agency, I wanted to give you a little overview. On our side, all of the cases begin with a worker complaint, typically in one of three areas of law. The first is protected time off law, which we'll talk about today. Then there is the Fair Work Week law, which provides predictable work schedules for both fast food and retail workers, and the delivery worker laws, which sets a minimum pay rate and protections for restaurant and grocery delivery workers. Just to give you a little heads up on what's coming, I'm going to talk through some of the definitions under the law, usage and the amount of protected time off workers are entitled to, and then some documentation requirements. Okay, so what is protected time off? Protected time off, formerly referred to as the paid safe and sick leave law, is protected leave available to employees related to their own health and safety needs or those of a family member, for childcare, public benefits, and public emergencies. So this law changed in the last month, actually. And since then, employees may use this leave to care for a child or family member with a disability, attend housing, public benefits, appointments, and hearings, and to stay home during a public disaster or public emergency, such as the blizzard we experienced last month, which was declared a public emergency. Another aspect of this law is the paid prenatal leave law, which went into effect at the beginning of last year, which entitles all workers, regardless of employer size, to 20 hours of paid prenatal leave. So workers can attend to healthcare appointments related to or during their pregnancy. I'm going to spend a little bit of extra time on this slide. I know it's a lot of information, and all of this information is, again, available on our website. New York City workers have the right to protected time off, and most workers have the right to be paid for this leave. This chart is available on the Notice of Employee Rights document, which I'll discuss a little bit later. And it outlines the amount of leave workers are entitled to based on an employer's size and income. Since I believe most people here are probably here for smaller businesses, we're really going to be talking more about this like 5 to 99 employees or more than $1 million in business earnings. So this row here, which is provides up to 40 hours of paid leave for workers, 32 hours of unpaid leave, and 20 hours of paid prenatal leave. The 32 hours of unpaid leave was a recent addition as of last month. This leave and the paid prenatal leave has to be available to workers beginning on their first day of employment and at the beginning of each calendar year. All of that leave is front-loaded at the beginning of employment or at the beginning of the calendar year. The next type of leave can be accrued, which means workers accrue paid protected time off at a rate of 1 hour per 30 hours worked. Employers also have the option of front-loading that time, which just means giving their employees all the hours at the beginning of the year. So you would give them 32 hours of unpaid leave and then 40 hours or 56 hours of paid leave and 20 hours of paid prenatal leave. This is very important. If both types of leave are available, employers should use paid time off before unpaid time off unless an employee otherwise specifies. And so protected time off applies to part-time, seasonal, and full-time employees alike. We received a few questions prior to this presentation about accrual rates of protected time off for part-time and seasonal employees. It's going to be the same as what I just mentioned. So employees, regardless of part-time or full-time status, accrue 1 hour per 30 hours worked, up to the total number of hours an employer must provide. So again, if you're in that 5 to 99 employee range, it'll be 40 hours of paid protected time off per year. Part-time and seasonal employees accrue that time at a slower rate just by nature of working fewer hours or over a shorter period of time, but they are entitled to accrue the same amount of protected time off required based on their employer size. There are some employees who are not covered by the law, government employees, employees subject to certain collective bargaining agreements, and independent contractors who do not meet the definition of an employee under New York labor law. As I mentioned before, family members, workers can also use protected time off to care for family members, and our definition of a family member is pretty broad, including the idea of a chosen family. So any person with whom the employee has a close family-like relationship, in addition to what you might typically think of as a family member. We also received some questions about documentation and what documentation is acceptable. This, again, is very important. Employers cannot require an employee to give them details about why they used protected time off. In fact, employers can only ask for documentation if an employee has used 4 or more consecutive workdays. That documentation can include something like a note from a doctor, a letter from a school or daycare if there's a daycare closure, and a couple other types of documentation. So I'm going to walk us through a couple of examples. So our first example is Maria. Maria began to feel sick one morning before work. She called her manager at a company with 10 employees and informed them that she needed to take the day off of work to rest. The next day, Maria was still not feeling well and decided to visit urgent care. She called her manager again and told them she needed to take a second day off. Her manager told her she can take the time, but it will be unpaid, even though she has both paid and unpaid protected time off available. Should Maria's time be unpaid? I'll give folks a couple of seconds if you want to just answer in the chat whether it's a yes or a no before moving on to the next slide. Okay, so the answer here is no. Maria's request for leave due to illness and then her visit to urgent care is protected time off. She should be paid for her time used. If Maria had used 4 or more consecutive days, her employer could ask her for a note from urgent care, but since she only used 2 days, she's not required to do so. Our next example is Ruby. And this is an example of using leave for safety reasons. Someone from Ruby's neighborhood has been following her. Recently, someone broke into her apartment while she and her 10-year-old son were out. No one was physically harmed, but Ruby suspects that it was the person who has been following her. She does not feel safe staying in her neighborhood anymore. She decides to move in with her mom, which is in a different school district. Ruby needs to take a day off from work to enroll her son in his new school and to move their belongings to storage and to her mom's apartment. May Ruby use protected time off? I'm seeing that the chat is not it's not open to everyone, so just answer independently. The answer here is yes. Ruby is taking time off from work to move for to move and to enroll her son in a new school because of the acts against her are some of the acts that constitute the crime of stalking. Stalking and threats are acts that constitute stalking are covered by the law. Covered employees may use protected time off to relocate and to enroll their children in a new school. Our next example is Francisco. Francisco needs to take a half day off of work to go to housing court to resolve a housing dispute with his landlord. And Francisco used protected time off to go to court. Okay, the answer here again is yes. Francisco is attending housing court proceedings, which means his employer must provide protected time off. And one more example. So Beth is a sales clerk and she has a daughter in daycare. The daycare center is closed for 3 days this week due to a school holiday. Beth has 20 hours of paid protected time off and 32 hours of unpaid available. Can Beth use 24 hours, 3 days of protected time off to care for her daughter? Yes, she can. Beth's employer must pay her for using 20 hours of protected time off and then provide 4 hours of unpaid protected time off. Because this is only 3 days of use, Beth's employer cannot require documentation. Okay, so I'm going to dive into some of the aspects of the law that are a little bit more specific for employers. The first is the Notice of Employee Rights, which is what the document I had mentioned a little bit earlier. We received a few questions about how employers should make employees aware of their rights. And the first way is by posting and distributing the Notice of Employee Rights. The link is available in the chat. It's also available on our website. The Notice of Employee Rights is available in many different languages, so you can customize based on the needs of your workplace. Failure to post and to distribute this notice is a violation of the protected time off law, so it's really important that you post this. If there's time at the end, I'll pull up the Notice of Employee Rights so you can get a look at it. The other aspect that's very important for employers is the written policies that you provide your employees. There are specific rules for protected time off available at this employer tool link, which is also available in the chat and again on our website. We received a few questions about this policy and about documents that employers should provide their employees. One of those was about setting caps on accrual and usage. This document gets into that, as does our FAQs, which again are on our website. An employer can set a cap on accrual and on usage, but they must allow employees to use the minimum amount of time required by law. So again, 32 hours of immediately available unpaid time off and 40 or 56 hours of paid protected time off, depending on employer size. The policies must include some specific categories of things, such as how much time off is provided by the employer, any notice and documentation requirements you might have, minimum increments for use, policies on discipline for misuse of protected time off, confidentiality rights. So again, with the documentation piece that we discussed earlier, you can ask for specific documentation. And the policy also has to include paid prenatal leave and cannot include any illegal language, for example, discipline for all same day callouts. And it is illegal to take action against or to punish an employee for filing a complaint with DCWP. Consequences for illegal retaliation include paying the employee's lost wages, civil penalties, and reinstatement. So when we receive a complaint, that employees' rights are completely protected, and as they go through the process, their rights are protected. But you should also know that retaliation is any action that could penalize or deter a worker from exercising or attempting to exercise any right protected by the law. This includes threats or negative comments, but can be more severe as termination. So we want to ensure that workers have access to these rights and that they feel empowered to use them. One brief example. So Kara has been working for Great Supermarket for 3 years and never received a notice of employee rights or her employer's written protected time off policies. She asks her manager about whether she can be paid for a day off because she needs to attend a doctor's appointment. Her manager tells her no. They have a short verbal disagreement. And then the next day, Kara is fired and is told it's because of her insubordination the previous day. Could this be retaliation? The answer is yes, this is retaliation. Kara attempted to exercise her right to paid protected time off, and her employer punished her with termination because of that attempt. So I wanted to preview some of the types of complaints that we receive at DCWP. The most common violations include employers not allowing an employee to use protected time off, not paying an employee when they do use their protected time off, retaliation for exercising their rights to protected time off, penalizing for use, or like our previous example, termination, not providing employees with a written policy or having illegal terms in their policy. Other recurring issues are replacement worker requirements. So that would be requiring one of your employees to find a different employee to cover their shift. It is incumbent on the employer to meet the needs of a business, so a worker does not need to find their own replacement. We also see carryover violations. So for employees who accrue leave, they must be allowed to carry over that leave up to the minimum amount required. So that might be 40 hours, depending on your workplace size, or 56, and accrual violations. So that can be a number of things, but limiting how much leave a worker can use, or not letting part-time workers accrue leave. So DCWP recently published a report with expected usage rates across several different industries, which includes a tool, the Protected Time Off Usage Compliance Tracker, which I will pull up in just a moment. Employers should use this tool and regularly review their employees' usage rates. Employers with average usage rates below their industry average should evaluate their protected time off policies and practices to identify and correct the violations that might be contributing to low usage rates. And I'll show you the report in a moment as well, but it's a great resource with an in-depth analysis of sick time use across industries, occupations, and demographics. The next slide talks through some of the common examples of violations we see. So common violations by employers are not offering a sick leave or protected time off benefit at all, non-existent or insufficient written paid sick leave or protected time off policies, inadequate or unlawful systems for administering sick leave or protected time off policies, absence control policies providing for discipline or other negative consequences when employees call out at the last minute or for a no-call, no-show, unlawful restrictions on employees' use of sick leave or protected time off. And again, this benchmarking report that I just mentioned, the link is available in the chat or on our website. The report includes detailed recommendations for how to address each of the violations I just mentioned. More information is also in our frequently asked questions section of the website, as well as information, examples, and sample notices to include in your workplace. Often violations of the law are not necessarily due to an employer not having policies, but a lack of training for managers. So managers who are not trained in how to implement the policies, which then creates a barrier to workers' use of protected time off. So it is very critical that policies are both in place and then actually implemented so workers can access protected time off and employers can avoid violating the law and avoid all of the associated penalties. Going to provide our information to contact us, but since it looks like we have a little extra time, I'm going to also just show a few examples of the documents that I mentioned that I think will really help. This is kind of an overview, and I think these will really help address some of the questions we received in advance about specifics for policies and hours required. So if you'll bear with me 1 second. Okay, so this first page is the notice of employee rights. Again, we offer many different translations of this document. And we've recently updated the notice of employee rights to reflect the change in the law that occurred last month. So this is a great time after watching this presentation to print this out, provide it to your workers. This again includes that chart that I mentioned earlier so that you're able to be aware. It provides a spot for you to put your calendar year. So if you're on a different fiscal calendar or something like that, you can indicate that here. And also this provides information about DCWP and how workers can file complaints. Sorry. Okay, so this document is the rules for protected time off policies. I mentioned kind of like the high level for each of these, but each policy has very specific requirements, and so this can help you guide you in both assessing your current policies to make sure that they're compliant, or starting anew if you don't have a policy in place at all. The benchmarking report that I mentioned earlier, it's very helpful, has graphs, all sorts of things, but also leads to a tool to assess your compliance, which is just this Excel document. I am not going to do public math and show you how to use it, but it's pretty straightforward and there are instructions on the first page. So I think that is everything for us today.
Oh, thank you so much, Alex. Everyone, I sent all of the links on the chat. I also sent if you need to file a complaint. If you have any questions, please utilize our portal. Definitely, when it comes to anything more personal, this is a free space. We definitely encourage people to ask these questions. I know, that all these laws keep updating, and it's good to always uh, make sure you're up to date with everything. And I always make sure I tell people you can always follow us on our social media at Hello DCWP. If you have any questions, you can always visit nyc.gov/workers and ask any questions. And yeah, I want to have a big thank you to Alex for the presentation, for our ASAL interpreters, Renee and Alyssa. Definitely thank you so much. And this will wrap up our DCWP 101 on protected time leave. So thank you everybody for coming and keep